Good morning, everyone, and welcome to today's webinar hosted by PYA. Today, we are continuing our Healthcare Regulatory Compliance webinar series with a presentation on No Surprises Act, the new independent dispute resolution process. PYA is happy to present today's webinar in conjunction with Crux Strategies. Before we get started with this webinar, I'd like to go over a few housekeeping items. As this event is for CPE credit, there are some additional steps we will take in order to comply with NASBA requests. Attendees will be provided 3 polling questions throughout today's webinar. Responses are documented electronically. Attendees must respond to these polling questions within the allotted time in order to receive CPE credit for this course. A post-event survey will also be provided for attendees to submit regarding their webinar experience. The polling questions and the post-event survey must be submitted for proof of participation today. You will have the opportunity to submit questions to today's presenters by typing a message into the question pane of the control panel. We'll collect these and address them at the end of the webinar or by email after the webinar. All of our webinars are recorded and released with a copy of the slides after the event. With that, I would like to introduce Bob Paskowski, Principal, and David Hall, Senior Manager at PYA, and Tim Gary, CEO of Crux Strategies.
Thank you, Laura, and good morning to our audience. Again, I'm Bob Paskowski. I'm a PYA principal, and I lead our managed care service line. And I want to kick off here with just sharing our agenda with the audience this morning. I'm going to have Tim go ahead and go through the No Surprises Act overview. This will be very much the rules and regulations around that act and some of the key regulations that will be feeding some of the other agenda items. So we'll have Tim do that. Then we'll turn it over to Dave Hall, who will review the IDR process step by step, as well as how the QPA, which are the 2 main elements out of the NSA, of establishing that QPA. And then I'll close with going through some of the initial learnings we're getting from this process initially and some potential strategies as you're contemplating this particular topic. But one thing I want to share as we get into the presentation today, I'd say most of the presentation is through more the provider lens, and we're mostly representing providers in these situations. And as you'll hear throughout this discussion this morning, these rules are all new, and everyone's kind of weeding their way through it. So keep that in mind as we go through this. And you know, that makes the game hard to play when you don't understand, or we understand the rules, but not necessarily how they're being played. So that's important as we go through this. So this morning is just about making sure we're educating you on this topic, sharing some of our initial thoughts and giving some options. So we just want to give that brief introduction. So I'll go ahead and turn it over to Tim Gary, who's going to go over the No Surprises Act overview.
Thanks, Bob, and good morning, everyone. And without getting too deep into the details and putting everybody to sleep before we get started, the No Surprises Act generally is a prohibition against balanced billing for out-of-network providers. I know there's been a lot of discussion about it. There's been a lot in the media about it. But the No Surprises Act was a part of the budget process for 2021. Federal process is a little bit different than a lot of state legislative processes that limit legislation to the scope of a caption of a bill or a section. Feds can light up a bill like Christmas trees. And in the excuse me, in the Appropriations Act, they included the No Surprises Act. And that includes a step-by-step independent review process, and specifically how you calculate a qualified payment, which is at the heart of it. And moderator, if you would advance the next, there we go. As I said, it's part of the Appropriations Act from 2021 and prohibits balanced billing. Basically, for those that haven't dealt with that, essentially balanced billing is you go into a hospital, you have a surgical procedure. You knew the hospital was in your payer's network, and you planned on paying your copay and your deductible, and that was what you expected this to cost. You have no way of knowing if the radiologist, the neonatologist, the anesthesiologist, all those other hospital-based physicians groups are in network or not. You hope that you really don't have to meet those folks, because if you're talking to the anesthesiologist or one of those folks, something has gone wrong. And you check in, and then you get a bill that exceeds what you were expecting because they were out of network. The No Surprises Act prohibits that and was intended to stop those quote unquote surprises from coming through to patients. There was an interim rule that was used to implement the prohibitions in July of 2021, which led to litigation by the Texas Medical Association, which led to a final rule in 2022. And if we could advance the slide here. The final rule led to new litigation, which is currently pending in the U.S. District Courts in Texas. And this really all relates to how the QPA is calculated. The rule applies just from general application to any facility, hospitals, critical access facilities, freestanding EDs, et cetera, and prohibits services that are provided to those patients in those facilities from being billed at out of network. As you can see there, it covers a wide range of government services, government funded plans. If we could just advance to the next one, I think we kind of get to more of the meat of this. Okay. Emergency service networks or emergency services that are furnished out of network is the situation that we described. And what has really led to a lot of the disputes over the application of this is the implementing rules. The way the process typically works is Congress will enact a law, and then they will delegate the authority to a government agency to implement rules. In this case, it was Health and Human Services. The rules that were implemented through the administrative rulemaking process set out certain criteria for calculating the QPA, the qualified payment amount. And it defined how those would work as far as, emergency services, post-stabilization, anything related to emergency services. If we could have the next slide, please. Okay, there are two components to how this was set up. One, you can give notice that you're an out-of-network provider to a patient and get them to sign a waiver. This is very similar to the process that CMS has used for Medicaid for years when they were having providers provide treatment to Medicaid enrollees for non-covered services. They would have to sign a notice that they were that they understood this was non-covered service and that they were willing to pay for the service. Same type notice and consent happens here. If service is scheduled, they're supposed to give you a good faith estimate of what the cost is going to be. And the out-of-network provider is required to have a consent waiver signed. Now, this is the first place that this gets a little bit tricky. This works fine if you're an ASC, an ambulatory service center. It works reasonably well if you're having various services in hospitals. But if you go through the rules specifically prohibit the notice and consent option to opt out of the No Surprises Act for the critical hospital-based physicians groups, emergency room services, anesthesiology services, neonatology, pathology, they cannot opt out. You have to go through, you would get on the other services a waiver that is signed. It has to be documented, and they have to retain a copy of that notice and consent. If we could have the next slide, please. Again, the patient can't be charged more than the out-of-network cost sharing amount under the No Surprises Act. Other state regulations take on a priority if they apply. And where you really get into the dispute is the way this is set up. An out-of-network provider is supposed to accept a payment after a 30-day negotiation process. If they're not happy with payment, they go to dispute resolution. But essentially, they provide a bill to the payer. Payer sends them a payment that is supposed to be the median in-network rate for that payer. And a lot of times, this works just fine. Where you really get into an issue is with highly compensated physicians' practices that employ a great deal of specialization, a great deal of training, a great deal of other criteria that take into account, the expenses associated with operating those practices. When you get into that component of it, the IDR sets out various components, the median network rate. The rule also encompasses education, complexity or acuity of the patient, et cetera. The interim rule that was initially issued set that, or was called into question in that they felt like that the rules, the providers that brought suit through the Texas Medical Association felt like that the rules gave too much weight, almost controlling factor, to a amount of the median rate that was set by the payer, sort of like letting work with those payment amounts to make them come out in the way that you want to. They challenged, the TMA challenged that ruling and found that the courts agreed with them in that you've got a cost sharing rate that's a numerical amount, and then you've got these other factors that are really very difficult to quantify. And the argument was made, and the court agreed, that the way that the rule was set up was really in violation of the spirit of the act, in that it provided way too much weight on that number in the QPA and left all the other factors out. The HHS entered an additional rule that dealt with patient liabilities, that dealt with the factors rather that should be put on the calculation, and we are back in court again litigating on that. But essentially, the payer furnishes a QPA with the initial payment, and the payment is not, the payment is going to be supposed to be the median or average median rate that the payer provides. Payer requires the QPA to be certified that it's compliant, or payers required that the QPA be compliant with the regs. And then there's essentially a yes/no decision-making process. If we could have the next slide, I think that's the one that actually gets to, see if that gets to the decision tree. Yes. If you walk through this, patient receives treatment, provider submits a claim against the insurance coverage, and the payer pays the amount. And if everybody is happy with the QPA, life is good, and you move on. If the provider is not happy with the payment, they provide notice to the payer that they believe it's incorrect, and they enter into negotiations. And the negotiations are typically a baseball type arbitration negotiation. You have a rate from the payer, you have a rate from the provider, and they negotiate in good faith, at least in theory, back and forth for 30 days on that. And then they decide if that payment is going to work or not. If the open negotiation does not reach a satisfactory conclusion, then you initiate the independent review process. At that point, the first real decision happens, and depending on which state you're in. Most states are utilizing the federal IDR process. A few states have had that process ceded to them by CMS, where they have an appropriate IDR process in place. So at that point, you have to figure out if you're following the federal rules or if you're following the rules of that specific state, because there are some nuances between those in how the IDR is calculated, or excuse me, how the QPA is calculated, and what the time frames are. Next slide, please. Okay, a few things to keep in mind. The No Surprises Act does not establish a network rate. That is left to the IDR process. It's outlined in the rule that it's supposed to be the median in-network rate for a provider. In theory, that would put all providers of that type. So if you're an anesthesiologist in a given market area, it should be the median in-network rate for your market and your services. And this is intended to smooth out the differences between provider group A and provider group B, but still establish a market rate. As you can see on the screen there, I guess I jumped the gun a little bit. Texas Medical Association challenged the interim rule, and we're now again challenging the final rule in how those calculations are made. But there's not a specific rate that is applied or established by the No Surprises Act. If we can have the next slide, please. Nope, okay, let's go back up one, please. I think I jumped the gun. Okay, thank you. In this process, there are a couple of other options. One, we mentioned before, if the IDR process has been ceded by CMS to the state government, a state can have an all-payer rate. And if that's in place, then that is used as guidance in calculating the QPA. If not, as we talked about a moment ago, there's the back and forth between the payer and the provider. And both submit estimates to the independent review agency. Independent review agency, I think, has 30 calendar days to make a decision on what that rate should be, and they issue a final ruling. You should be careful to note that, as Bob alluded to early, you've got a general law that has been enacted by Congress that says we think this is a good idea, the patient should not be surprised. I doubt anyone disagrees with that. The devil is always in the details. We now have rules that are being established, part of them by the rulemaking process, some of them by the courts as they are being reviewed, that set exactly how you implement that. And those rules are not soup yet. They're not completely finished. There's a lot of gray area. There's a lot of unknowns. There's a tremendous amount of back and forth. Can you use rates? For example, when you're setting the QPA that is from active providers, or can you pull the contract rates from, in the case of an anesthesiology code, for example, are you using the rates for anesthesiologists that are in network that are actively serving hospitals, which is what I think the rule is intended to do? Or can you pull a 10-year-old anesthesia code from a primary care physician that hasn't billed that code in the last 5 years and meld those two together? That's one example of the ambiguity and the confusion that is here. And this is going to be a really drawn out and somewhat surprising process, if you forgive the pun, on the No Surprises Act as we go along until those rules really firm up. No one really knows on the payer side how much leverage this gives them. in both setting rates as well as in contract negotiations. On the provider side, the rules are still in process and are being made up. One of the key pieces, though, is the October 22 interim rules did establish a rebuttable presumption on the QPA. And a rebuttable presumption is purely that it's a theory in law that here is the rate, this is what the payer has provided. It's presumed to be correct until there's a weight of evidence or data on the other side that shows why that is not correct. So you start from that standpoint, and then the burden essentially shifts to the other side, in this case, the provider, to show that that rate has been calculated incorrectly. And an example of that would be where you've got active rates from a provider that's from relatively new contracts or contracts that are in place today, and this is the rates that we're billing for these codes, versus a melded contract rate that uses out-of-date information or speculative information going forward. That has really been where the biggest disputes have come about so far, along with how the rules are going to be written. Now, the Texas litigation, the decision from February is in the Texas Medical Association case about the interim rule related to the EPA or QPA violated the Administrative Procedures Act. And they went back into that and rewrote it to give due weight to other factors. And this is where this gets really kind of sticky. You have a rate that is a median calculated number. Then the other factors are the education and the background of the provider, the complexity of the case, et cetera, that are really not numeric factors. And we're back in court now figuring out exactly what does that mean? How are you going to apply it? Because you're applying numbers on one side, that's pretty easy to understand. And then you're picking up on non-numeric factors that are hard to quantify. And that is going to be an issue for the courts and for the rewrite of the rules, I suspect, for some time. All right, with that, let's go to the next slide. Polling question number 1. Can we put up the questions?
Thank you. Our first polling question is, where is the federal independent dispute resolution process defined? Regulations for good faith estimates, July 2021 interim final rule with August 2022 final rule, state regulations with federal rules, or payers online provider handbook. Remember, you must fill out the polling question in order to receive CPE credit. You will have 30 seconds to answer. Thank you for participating in our poll. Now I'll hand it back over to Tim.
Well, this is the part where we figure out how badly I confused you. The questions or the answers that have been submitted were regulations for the good faith estimate, July 2021 interim rule with the August 22 final rule, which gets 67%, state regulations with federal rules, which gets 17%, and payers online provider handbook, they got 1%. So the vast majority of you got it right. The July 21 interim rule with August 22 final rule. Laura?
Hello, everybody. This is Dave, David Hall, PYA. I'm a senior manager, and for the last 2 months or so, Tim and Bob and myself have been working through the IDR process. So part of what I'm going to do today is to talk you through the IDR process, the federal one, and then we will hand over to Bob, who will then talk about some of the lessons we've learned and possibly some of the strategies that you can consider as a provider going forward. So, right. Oh, sorry, one slide too far. All right. So the IDR process is set out in great detail within various guidebooks, and we provide those guidances, links to them further on in the slides. The IDR process, which is basically when you start going into just after you've gone through the negotiation period, you go into the IDR. Now, if we look through this, the QPA, as Tim set out, is the starting point. We really start at the QPA. We then go through the negotiation period, and then we can initiate the IDR. I won't go through every single detail of this, but it's a very, very time-constrained process. From the provider point of view and the payer point of view, you have to comply with these deadlines in terms of meeting the deadlines. So part of the process that a provider needs to do is to track all of this. And so part of what we've been doing, working with our clients, is to develop trackers to make sure that we know exactly when open negotiation started, when the open negotiation ends, and then the trigger dates for sending the IDR notification, etc. So you, as a provider, somebody contemplating going through this process, you really need to make sure you understand these dates, have a complete list built out of when those dates are going to be triggered, and follow those dates accurately. If you miss a day by a day or two, then you actually could invalidate your entire IDR process and lose by default. So that's very important that as part of this process, you go through, understand these dates, understand the steps needed, and follow those, track it, and make sure you're adhering to that process. One of the things we'll talk about later on is there are some delays within the IDR arbitrators, but that's nothing that we as providers can have any sort of impact on, and it doesn't invalidate the final process, but we have to stick to our part of the rules in terms of the dates. One of the other things that Tim alluded to was at the end of the process, the end of the IDR, the arbiter comes up with an answer which is either the number that was suggested by the provider or the number that was suggested by the payer. So it's one or the other. He cannot, the arbiter cannot say, oh, 50-50 or let's go negotiate. He's got to either come up with, you select one number or the other. And then you pay that after the 30 business days. There is another step beyond this, which is a 90-day cooling off period during which no further IDRs can be submitted for the same service. So the entire process from beginning to end can be 140 days or more. So not only have you got to plan for this, but you've got to allow for the fact that the whole process is going to take many months. And given the additional delays caused by the some of the hiccups within the IDR process itself, within the arbiters, it could go out way even beyond that. So this is something you really need to be aware of and be to track this. So having a good tracker, being aware of all these steps, following the rules, absolutely essential. So the determinations, again, Tim alluded to these. So outside of the QPA, which is the number one main important part of this, are some additional information that a provider can provide. I won't go through every one of these in detail, but let's assume that market share is important. But again, it doesn't say whether a high market share or low market share is good or bad. It just asks you to provide it. The acuity of a patient is again asked to be provided, but there are certain assumptions, so you can't double count. So if you're saying that the care was provided by a neonatologist, there is an assumption that that neonatologist has a certain level of training, skill, and ability, and so you can't go in and say, oh, this neonatologist had very high skill and ability, because that's assumed within the code for the service. So double counting is something you've got to be very careful of when you are preparing an IDR. So you've got to have exceptional information, not just really restating what the code implies. One of the other things which we'll come on to when Bob's talking about is potentially some payers are using the whole No Surprises Act as a kind of weaponized way to reduce rates. One of the potential solutions to that from a provider point of view is one of the things that is submitted with the IDR is if you had in-network rates within the past 4 years, and those can be used as part of your defense for the number that you are asking for. So if the payer specifically gives notice to try and use the No Surprises Act as a tool to reduce rates, which has, as we've observed, been happening, part of that is to say, well, we've been in network for the last 10 years. These are the rates. Those rates then become part of your defense within the IDR. So when you get to the very end, the IDR entity is supposed to give a complete written explanation of the information that was used in accepting the offer, whichever offer they chose. So I think it's important to be looking for that. In our experience, it hasn't necessarily been that helpful, but hopefully, that may give information, because if you're going on to subsequent IDRs, you want to learn from the information that you get from any early IDRs. So the QPA, again, Tim talked about the QPA. This is the very start of the IDR process. You start with that QPA. There's regulations on how it's calculated. Tim alluded to this kind of ghost rates, which may be used by some payers. But basically, this is supposed to be a defined amount based on the in-network rates for that particular payer for the same service, for the same kind of plans. So they can't be using Medicaid rates or Medicare rates. They must be the commercial or the self-pay plan rates. In challenging the QPA, whatever the provider does, it must be a credible case to persuade the IDR entity that it is not a good rate. In other words, there's an assumption which Tim referred to, which is that the QPA is the correct amount, and it's up to the provider to come up with a credible case to persuade the IDR entity that that is not the correct case. Now, that is not necessarily an easy thing to prove, because the assumption is that it's the correct rate, and the assumption is that they've calculated it correctly. They should be certifying that it was done so. So the starting point is that the QPA is assumed to be correct. Now, that is being challenged. That rebuttal assumption is being challenged, but from a provider point of view, that's a very, very difficult thing to undermine. Again, we talked about the strict timelines. And again, just to say that given the information we've got so far and our experience, submitting an IDR is a very high risk strategy, and that if there is any other ways that you can come to a negotiated settlement, that is highly advised. The IDR, we don't know the numbers yet. We haven't got any success failure rates, but given the information we have, the success for a provider in submitting an IDR is unknown, and there is a pretty significant chance that you're going to fail. So even with the best IDR submission, you've got to really contemplate that outcome. The other thing just to mention here at the end is the concept of down coding. So when you submit a code for a service, one of the things that the payer may do is down code the service to a lower code and pay on that amount. And they should indicate that in their EOB. But when they provide the QPA for the service, they should provide the QPA for the downcoded service and for the higher service that you were originally submitted for. So again, be aware of that. There's a whole series of rules and regulations around downcoding. All right, so we've touched on this. This is the July 21 rule is reaffirmed in the August 2022 rule that this is the way that the QPA is defined. So again, it's the median rate, and it has to be group health plans or individual plans in the same insurance market. The same insurance market is not necessarily defined, so that's an open area for interpretation. There are alternative methodologies for calculating the QPA. Won't go into those in great detail, but there are opportunities to use third-party databases, and we have seen that used in some instances. Those have to be agreed between the parties, though, if they are going to use a third-party database. Again, I won't go to this one in a great deal of detail, but there's a lot of information that should be provided by the payer with the original payment. So the QPA should come with a series of extra bits of information, which tells, number one, a statement certifying that that is a QPA that was calculated correctly, and various other bits and pieces in here. And there are additional information that you as a provider can ask for, but it's not everything you probably want. So you should get information that comes through with the QPA, with the EOB. You can ask for additional information, which is highlighted here, but it's not going to be probably everything you need to be able to dig into exactly how that QPA was calculated. They won't, for instance, be required to say which contracts they used and which contracts they haven't used. So in other words, it gives you some more information, but it's limited. So again, this is really just the information that you should be expected to receive and the information that you can ask for. I won't spend a lot of time on that. So part of the information that the payer is asked to provide to the IDR entity is outlined here, including the practice size and the specialty that they use, including the geographic region, etc. They don't necessarily have to provide that information to you, but they have to provide it to the IDR entity. One of the big underlying things within this whole process is all the information that's provided by both parties has to be credible. In other words, it has to be specific to the service that's provided. It has to be specific in theory to the patient and the actual event for that patient. So when they look at the claim, they're not looking at a general CPT code. They're looking for the event specific to that patient for that episode, for that specific claim. So whatever you do as a provider and you submit that additional information, it has to be specific to the provider that provided it, the physician. It has to be specific to the patient. It has to tell the story of that patient and why you feel as a provider that you're entitled to more money than has been offered. And this all goes as part of the story that Tim was alluding to, but you have to effectively prove that the QPA is not meeting the needs of that particular patient. So the QPA does not reflect the service that was actually provided. And that the burden of proof seems at the moment to be with the provider to prove that the assumption is almost that the QPA is correct, unless you can demonstrate that it's not. So again, the assumption here is that you've got to prove that the QPA is not credible. So you've got to try and come up with evidence to say that the way that the QPA was calculated is not in accordance with the Act, and it does not reflect the specific claim for the specific patient that you are submitting to the IDR. So that again, that's very difficult to prove and to tell you exactly how to do it, but that's the hurdle that you've got to overcome in submitting the IDR, is to undermine and challenge the QPA as being not relevant for this patient and is therefore, is not credible. So we come on to polling question 2. Over to you, Laura, please.
Thank you. Our second polling question is, how is the qualifying payment amount calculated by the payer? The median contracted in-network rate for same or similar service or similar geographic area, according to July 2021 final rule, must be the rate paid in the independent dispute resolution, median in-network rate for 2019 rate plus inflation, or the lowest rate the payer has contracted. Remember, you must fill out the polling question in order to receive CPE credit. You will have 30 seconds to answer. Thank you for participating in our poll. Now I'll hand it back over to David.
All right, thank you, Laura. Okay, I think most of you got the answer right by looking at this. It is calculated based on the median in-network 2019 rate plus inflation. That is the correct answer. The July 21 was not the final rule, it was an interim rule, so that was a slightly tricky question. But thank you everybody for participating in that. I will now hand over to Bob.
All right. Thank you, David. Okay, so given all the background, we just want to share here, what have we learned so far in this early part of the process? And we want to just share some of that information on these next few slides. The first one is around just that this whole process is still in development. One thing I think you heard earlier was that there's a federal IDR process, but there are some states that have taken on that responsibility from the federal government. I believe there's approximately 4 of those. So really that's important to know who would be overseeing this IDR process. Payers are, what we're also finding is that payers are not consistently providing the required QPA information. I've looked at a lot of these EOBs from the payers. I've not really seen a lot of it at all, where there's a specific footnote that says this does represent the qualifying payment amount. So it's just not happening as the rules do indicate. There's a lot of delays in this IDR process. I was fascinated by the article that just came out about a month ago from Modern Healthcare. You can see some of the statistics, but just the fact that just as of a little over a month ago, that 46,000 disputes have been filed. And just wrap your head around that. That's a lot. And very few of them have been decided. And as David went through a little bit earlier, it's very important from really both sides that as you're submitting the information to the IDR, that it meets all the eligibility requirements. Did you file within this amount of days? Did you collapse claims in the right buckets, et cetera, et cetera? Because what happens in that IDR process, as the information's submitted, they're going to go through that process and say, okay, this batch is too late, it's not eligible. And you can see here from some of the initial statistics that many of them were being challenged and frankly were kicked out of eligibility just because the process was not followed and was not timely. And again, some of these are even been been rejected. This is the other thing that's pretty fascinating to me, that already 3 of the 11 federal IDR entities have almost closed their panels, that they've run out of capacity to hear more of these cases. So there's obviously a bottlenecking going on there with these claims. And you've heard this theme again, that of all the different pieces of the puzzle, that the QPA seems to carry the most weight into these decisions. We've heard a little bit about ghost rates, and there's been some writing in this in some of the literature as well. But I just want to make sure the group here is aware of what a ghost rate is. So if there's a particular service that is under investigation here and going through the IDR process, and the payer is submitting all of their rates for those particular codes, they could potentially put in rates that are not related to that specialty. And what that does is typically draw down the average of that in-network rate. And so they're adding in contracts and rates that are drawing down the average, which is what they're submitting to the QPA. So it's important as this information's pulled, that it's got to be pulled out to make sure that that rate is not being diluted to a lower amount. But again, just if it's, the QPA is required to be credible related to these services. And again, just knowing your marketplace, identifying providers who may also be included in the QPA. Again, just trying to get as much information you can get out of the market to figure out what is a legitimate QPA, and getting rid of things that don't belong there. There's the other thing I want to point out here is that there's no requirement for a weighted average. It's that second to the bottom bullet. And so it could be a contract that's very low, but there's hardly any activity with that particular provider. Yet you may be in a position where you're the market dominator, so it could be 1 or 2 smaller rates with very little activity in the marketplace that will go into that average. So there's no weighting of those rates as well. David hit this quite a bit. I won't reiterate here, but the record keeping is pretty phenomenal. I'm trying to keep track of all this information. The data's got to be very clean as it's being submitted, making sure it meets all the requirements. And we are finding that there's quite a bit of variability observed in some of these out-of-network rates, and that, again, making sure that that you consider the member and patient responsibility as part of that. Filing, again, on time, very, very important. And what we're also seeing is we've found that a lot of the payers are using third parties to handle their out-of-network QPA claims. Firms like Zealous and Navigard have been able to provide that service on behalf of the payers. And so you may be working with them as part of this process. But at the end of the day, what does success look like? In our view, it's to try to get an in-network rate if that's at an acceptable market rate. Otherwise, this process can get very burdensome, very taxing on your organization to get these filed. Okay, Laura, polling question 3, please.
Sure. Thank you. Our third polling question is, when is an independent dispute resolution appropriate as indicated in the No Surprises Act? To overturn denial for an out-of-network orthopedic surgery claim, an out-of-network anesthesiology payment dispute and an in-network facility, notification of network agreement termination, or facility claim dispute for out-of-network claim. Remember, you must fill out the polling question in order to receive CPE credit. You will have 30 seconds to answer. Thank you for participating in our poll. Now I'll hand it back over to Bob.
Okay, thanks, Laura. Actually, it's pretty close to a tie. The actual answer is the out-of-network anesthesia dispute, the one in the middle, which is pretty close to the top, but that is the correct answer. Okay. Okay, we're going to close here with some potential strategies given the background and at least what we're starting to see in the marketplace. Again, what we should all be putting toward the top of the list is trying to secure an in-network agreement at an acceptable rate to avoid the need to do the IDR. The other thing we would probably advise there is also look at termination language in those agreements, because what we're finding is, and I'll get to this in a moment, that if you're potentially above the QPA, that payers may be taking the approach of terminating. So if you've got short termination time periods, you may be back in this process. So if you can get that in-network agreement and try to make it for a little bit longer term to avoid the IDR process again. Determine if federal or state IDR process applies. As mentioned earlier, most of these are going through the federal IDR process, but there are a few states that are doing that. Engaging allies. We've got hospital on here, and I think this is an important topic in that even though the hospital may not be, directly affected by an out-of-network or an IDR process by, let's say, a hospital-based provider, if there are cases where they're having to take lower rates and it's affecting their business, and that could present operational issues as far as time covering in the ER or covering in surgery, then the hospital may need to at least be aware of that situation of going out of network and putting pressure on the organization from a financial standpoint. Build out the timeline, knowing that what has to be done, as David shared earlier around the timetables. You're talking at least if you go out of network today, it's usually 90 to 120 days till you may get that first IDR decided, so you kind of know where you stand in that process, and can you afford to take on that cash flow hit during that time period. Again, consider continuing to accept the QPA rates. Again, that's just more of a business decision. And again, like most decisions, what happens if it goes this way? What will we do if it goes a different way? And just understanding your different options there. I like this chart a little bit, and again, we split it here between offense and defense, and I've kind of equated to like a bar, and with a median rate, there are rates that are above the bar and there are rates below the bar. The rates above the bar, from a provider perspective, you're probably may not be saying much, but in the position, if you get in the position where a payer starts discussing about termination or just issuing termination letters, then you got to play defense. And if you're below that bar and you're not getting paid the right amount that you believe, then you start playing offense and you go through the IDR process to increase your out-of-network rate. And just something to keep in mind here is that, because of the surprise billing and not being able to balance bill patients, if you're out of network, you had the ability prior to 2022 to bill a patient for anything over that rate, called over usual and customary. That option's gone now in this process. So that's a loss of revenue. So I think those providers should be looking at opportunities to potentially get back to the payers and to try to close some of that gap. But you can see some of the things you could do if you're above that bar and trying to open up the IDR process to get the rates at a higher rate. From a defense perspective, this is tough, and we're seeing this around the country where there are terminations being issued by payers to try to lower the rate. So starting to be prepared for those potential actions, continue to negotiate evaluate the marketplace, understand all the moving parts of that. And one of the things that will have to also occur in the federal process is that both entities have to agree on the IDR entity. And if you've gone through an IDR entity already that wasn't perhaps a good process or wasn't a good experience, you have the right to not accept that entity in the next IDR. So keep that one in mind as well as an option for you. And just here's some tactical things. Again, this is challenging, but request that the payers show their computation of the QPA. It's just critical in how they're getting that average. And again, this is where we get into the ghost rates we talked about earlier, making sure that there's not some of those rates in that calculation that is skewing that answer. Researching your own market and trying to find out where you're at in the market compared to both the in-network and the out-of-network rates. Keeping great records. This is a lot of an accounting process as well to try to track all these claims, get them filed both timely and compliantly. And challenge the downcoding, as we know that many of the payers don't always pay the claim that's submitted. Make sure that those downcodes include both the QPAs include on both the original claim and then the downcoded claim. So just some tactical things to take away here at the end of the presentation. So that's the end of that, and I just want to put a plug in here for our next healthcare regulatory roundup, which is near getting ready for the end of the public health emergency. That will be presented by our PYA team on October the 19th. So I will turn it back to you, Laura.
Thank you. And thanks to our presenters, Bob, David, and Tim. If you have any questions, their presentation and contact information will be emailed to you, along with a recording of today's webinar. Also, if PYA can provide assistance with audit, tax, compliance, valuation, or physician services, call or email us. You may also visit our website at pyapc.com for more details about our specific areas of expertise or to subscribe to receive PYA insights. Please remember to stay on the line once the webinar disconnects to complete a short survey for CPE credit. On behalf of PYA, thank you for joining us and have a great rest of your day.